Turning now from Capitol Hill to the college campus, where my next guest says the outgoing Obama administration has used the federal anti-discrimination law known as Title IX to stifle free speech and deny due process in campus sexual assault cases. Robert Shibley is the executive director of the Foundation for Individual Rights in Education and author of the book Twisting Title IX. So, Mr. Shibley, welcome.
Thank you for having me.
So you wrote for us recently that there are kangaroo courts on campus in dealing with these kinds of sexual assault accusations. What do you mean by that?
Well, campus courts, even though many times they are trying to determine the same facts, whether or not a sexual assault or harassment occurred on campus, they have very, very low standards for making those determinations. And part of that low standard is driven by activity and mandates from the Department of Education in Washington, D.C.
All right. So as I gather, they only require a preponderance of evidence standard, which basically means if it's a kind of 50-50 case, as long as you get up to 51%, it's okay. And that's a very different standard than you'd get in a general criminal court, for example. Is that the issue? Is that where it comes down to?
Yeah, I think that's a big part of the problem. One of a higher standard of evidence than preponderance is one of the very few due process protections that students at some colleges were able to count on before this 2011 Dear Colleague letter that came out with this mandate. We think, and we are actually involved in a lawsuit saying that it violated the Administrative Procedure Act, putting that mandate in place. And so what's happened is now colleges can be far, far less certain of whether or not an assault occurred, or even whether it's they've got the right person for the assault, and still punish them. And
they have to do that because they live in fear that if they don't do that, the administration, the Obama administration, will crack down on them and and punish them in some way by denying them federal money, for example, if they get a big controversial case that the government doesn't like.
That's right. The punishment is actually the withdrawal of all federal funds. The punishment that would be a death penalty for most campuses, public and private. Almost every university in America, public and private, gets a lot of federal funds, particularly from Pell Grants and Stafford loans. And this punishment is so severe and so scary that it's actually never been implemented before. But colleges are worried that if they don't follow these dictates, that's what's going to happen to them.
Well, you would agree, I assume, that sexual assault is a problem on some campuses. I mean, you're talking about young people here, young men in particular, some of them not very mature. So how do you, and I think the administration would say, look, we need this tough standard to be able to stop what is this rampant problem on college campuses. What's your response to that?
My response is that if sexual assault is happening on campus, that's really a matter for law enforcement. These are serious crimes. They deserve serious investigation by people with the tools to actually conduct those investigations in a competent way. And we're seeing, I believe, at our last count, more than 130 lawsuits from students who feel like they have been unfairly found responsible for sexual assault on campus, the vast majority of whom were never prosecuted by the police or outside law enforcement, who ought to be investigating.
Now, your organization is participating, helping with some of those lawsuits. How are they proceeding in court? Are you winning those, or is it too early to tell?
Well, it's too early to tell. There's been a lot of motions practice back and forth, so we'll see how that goes forward. But we're involved in one case particularly really targeting that preponderance mandate from the Department of Education. Okay,
if you were, so you're Betsy DeVos, you're the new Education Secretary. Let's say you're confirmed. You come in. What do you do to stop this? How do you send a signal that this is going to stop and you're changing, going back to, I guess, the pre-Obama standard?
Well, because they didn't actually go through the proper procedure to get these written as official regulations, it's actually as simple as sending out a new Dear Colleague letter saying, you know what, we withdraw the preponderance mandate and other aspects of the 2011 Dear Colleague letter. They also need to revise the way they are defining sexual harassment. Right now, they're defining sexual harassment so broadly that overhearing a single dirty joke is technically sexual harassment on a college campus.
Wow.
There's no way that can be sustained under the Constitution. Constitution. They know that, and they ought to stop promulgating that definition immediately.
But you don't have to send, she doesn't need to do a formal rulemaking in that case. All she needs to do is essentially send alternative guidance saying that, that what you got, that letter you got in 2011 and the standards that the previous administration had been enforcing no longer apply.
That's right, and it is, you know, while it is sort of simple, it's not going to be easy. I think there'll be a lot of political pressure on them not to do that, but frankly, it's the right thing to do, and you know, it definitely would send a signal that colleges ought to be able to come up with their own standards and figure out how to do it best on their campuses with law enforcement.
All right, thank you, Robert Shibley. Good to have you here.